totality, including the original Rule 60 filings and the ensuing filings before Reporter Patterson. I've had the chance to read what you have submitted on the questions that I just outlined, which we are here about today. But I'd like to give you a bit of time, about 15 minutes, to address those questions for me, and then I'll give an equal amount of time to Mr. Coppola on behalf of the plaintiff, and then we'll see where we head from there. And you're welcome to stand either at the table or at the podium. I just would ask you to stay very close to one or the other of those microphones so that I and everybody else in the courtroom can hear you well.
Yes, Your Honor. Good afternoon. Just for clarification, I wanted to make sure that you received my supplemental filing.
Oh, I did, yes.
Okay.
And I have seen it. I haven't seen anything in response to that from your brother. Is
I
that
did
right?
not receive anything, Your Honor.
No, Your Honor, I did not.
All right, I just want to make sure I'm up to date, but I have gone through that as well, with all the exhibits.
And based on the order of April 25th, today the two issues are procedural. And as you said, the first issue pertains to that as appellants and defendants, that we are requesting that you, being the presiding judge over the judgment and orders related to the summary judgment, that as a matter of law, that it is necessitated that you be the one to preside over the presiding over the merits that will later be presented regarding the Rule 60B claims.
All right, let me pick up on something you said. You just said as a matter of law. Make the case for me, please, that as a matter of law, I'm the only one who can consider and act on the Rule 60 motion.
Well, to clarify, it's not that you are the only one that could ever hear this particular matter. However, under these particular circumstances, it is necessitated that you be the one, given the case law that I have presented in my memoranda, especially my supplemental memorandum, that Rule 60s, as far as the appellate court has established, that it is very important that the judge who actually was at the hearing, hearing the testimony, if applicable, the oral arguments, that presiding judge be the one that has to, since that judge has already heard the underlying case where it is raised that there are facts that were concealed from the judge, that it goes to the very fact of those findings. So it's very important that the presiding judge, who actually heard the initial oral argument and based the rulings on that specific set of facts that were presented, that now, under Rule 60, where, as appellants, we're now coming to you as having been the presiding judge and giving you substantial evidence that there has been information that has essentially that a fraud has been perpetrated upon this court, and that you will not.
I apologize for the interruption. Let me just ask you this. there seems some suggestion in some of what you filed that the recorder herself lacks statutory authority to act. Is that a position you continue to adhere to?
Yes, I do.
So, and what is it about the statute that you think does not afford the recorder the opportunity to hear and decide matters in a tax foreclosure case?
Because as given the statutes provided, it specifically states what the authority is.
That's section 6 of chapter 185 that you're looking at in the first instance, right?
That's correct.
Okay, and the last sentence of that says, the recorder shall have the same powers as a clerk magistrate, the Superior Court Department of the Trial Court, insofar as such powers relate to civil matters, and shall have the authority to hear and rule on petitions for tax foreclosure and for redemption from tax titles pursuant to Chapter 60. So where in that statute is there a want of power in the recorder?
And I present specifically as well the clerk magistrate, where the powers are specifically limited. If you give me 1 second to be able to
Well, that's okay.
get the statute, because
Let me just ask you though, so is what you're saying that the recorder of the land court has no authority to hear anything in a tax foreclosure case?
no, that's not my position.
So what is it about this statute that differentiates what is now being asked to be decided from all the other tax foreclosure proceedings?
Because there's a difference between acting on a summary judgment motion, reviewing of the merits, and then after there's been an order that the recorder has the authority then to act on the execution of such.
I'm not following your answer. Maybe you could help me with it. So what is it that the recorder under the statute lacks power to do in a tax foreclosure proceeding?
Well, that's what I wanted to, if I could just refer to the actual statute. If you just give me 1 moment, please. I think I misplaced my section.
You're referring here to the statute that governs the
Yes.
power of a clerk magistrate in the Superior Court in civil matters?
Right, but the way the wording is, and I'm sorry, I don't have the statute at my fingertips there. But the way the wording is, that statute is not set out in the language that says that all proceedings in a tax foreclosure case is permitted. Otherwise, there would be no need for that statute. The whole statutory purpose is that it's delineating. And it's very similar to the clerk magistrate in a superior court, where a clerk magistrate is not able to hear a trial.
Well, the statute has in its final sentence, two thoughts. One is drawing on the comparable authority of the clerk magistrate in the Superior Court Department relating to civil matters. And then it goes on to say something else, which is authority hearable on petitions for tax foreclosure pursuant to Chapter 60. So you think that that second grant of authority is somehow limited by the first and not more expansive of it?
Yes, it is limited, and it's not
And
meant
what's
to.
the authority for that assertion?
I suggest that the statute itself, the statutory language, I suggest that the language itself does not connote that the recorder can hear all matters pertaining to a foreclosure tax lien matter.
So I'll ask you again, what is it that you say the recorder cannot do in hearing cases brought under Chapter 60 for foreclosure of tax time?
I would suggest and submit that that means the recorder is not permitted to hear matters in which there's going to be a finding as to the rights of the parties and rights and liabilities.
In a
We're talking
tax
about the
foreclosure.
merits of whether a tax lien exists or not. And so, in fact, I believe in one of the transcripts, even the recorder herself actually had stated that she, my clients who were pro se at the time were trying to give representation of the facts and present, their case and so forth. And the recorder had said, I'm not the judge, that's something that will be heard by the judge. When you're talking about something of merit, something that, that the trial or fact needs to be able to go through the factual matter of the case and be able to make those factual determinations of whether even a genuine issue of material fact exists, that's for a judge. And
Ms. Bellinger, you're aware that for decades, since this statute was amended, I think John Fenton was then the Chief Justice of the court, the recorder, not this recorder alone, but those who have preceded her in office, have entirely on their own heard and decided tax foreclosure cases under authority of the statute. Many, many cases have been reviewed in the appellate courts without any controversy.
well, and I think that's probably the key, is without controversy. So I guess the matter is that nobody's challenged it, and just because something's been going on for 30 years, just because it's been going that way and no one's contested it, doesn't mean that it was done under proper authorization. So maybe this is a case of first impression, but just because that's the way it was done, I suggest that doesn't mean that that was permissible.
All right, very good. I have your position on that point. Before we leave this first question, let me also turn to something else you said. You referred at a number of points to the hearing of evidence, judging credibility, the trier of fact. This case has not gone to a trial. There has not been an evidentiary hearing in the life of this case to date. And the judgment that issued on an order for summary judgment that was entered back in 2013.
Right, and if I gave the impression that I gave an indication about that this particular matter was about a matter of weight of credibility, I misspoke. That's not, the fact, this isn't just about credibility in terms of witness testimony. We're talking about representations that are made by attorneys as to what the facts are. And that's a pretty large issue here, because it shows from the record that this court has actually, in the January 2013 order, shows that in the footnote that the facts were uncontested. And it appears that this court only had the filings submitted by the plaintiffs. And in further support of that, I had submitted a motion to the Command Court that dealt with a motion to amend and clarify the land court record for appeal. And there were, numerous itemizations that I had pointed out that were either inaccurate or were omitted, and listed out specifically what the issue was. I had specifically pointed out in that motion that the appellant's undisputed facts and exhibits and related pleadings were not docketed. And I had asked the reporter, well, actually, it wasn't specifically the reporter, I had asked the land court to please allow me the opportunity to be heard as to the numerous defects in the court record. And as can be seen from the docket that I've provided from the recorder's order, on April 15th, it shows that the reporter had allowed part, and it actually says all denied, but in actuality, as can be seen from the order on entry April 15, 2016, certain types of information were corrected and entered onto the docket. However, specifically, the defendants' undisputed factual findings were not reported on the docket, and the reporter has refused, even though it had been filed.
Okay, let me just review the docket with you on that. I think this goes a bit beyond what we're here about today. But the filings that I'm looking at that were made mostly in the fall of 2010 on summary judgment include, among other things, the plaintiff's statement of undisputed facts and legal elements filed on the 24th of September, and then a response to the defendant's statement of undisputed facts that were filed. And then there is the plaintiff, a town's motion to strike the defendant's statement of undisputed facts. And there is a response to the defendant's certification authenticating evidence in support of their motion for partial summary judgment. The plaintiff's appendix is shown as filed, as is the defendant's motion, which came in, looks like July 21st, for summary judgment, with a brief in support, with affidavits filed, with an appendix filed as well. And so the other thing I wanted to ask you was, after the order issued on summary judgment, there were multiple motions for reconsideration that were filed on your clients.
Right, but I'm not even going there. I'm going straight to the initial...
Let me just complete my question to you, please. So, if you were concerned I'm not sure that you need to be, based on the docket and my understanding of how the summary judgment order issued. But if you were concerned that your clients, because you were not representing them at the time, were concerned that the order on summary judgment issued without appropriate consideration of any of the assertions of undisputed fact that came in from your client's side of the case, you had, I think, a minimum of 3, maybe 4 sequential motions for reconsideration of that order. Was this point raised in any of those motions for reconsideration?
Actually, yes, there was a motion filed by Kimberly Raymond, who I believe was in her motion to withdraw, where she did address the numerous documents that were not on the docket. So, yes, she had addressed it in her motion. But, so, and my understanding is that a hearing was not permitted on that, and my understanding is that an appeal was filed but not allowed to be filed, stating that...
Well, there was an appeal filed prior to judgment, which is contrary to what the rules require.
Right, and I would suggest that was ineffective assistance of counsel for not going to interlocutory appeal, and that that during that time, as can be seen from the motion to withdraw, a good part of this litigation, my clients were pro se. There's a very small time frame here in which they were represented, and then they were having to fend for themselves again, and that under Rule B6, that the doctrine of equity definitely applies, that given the nature of information that was not apparently, say, under judicial review, that my client should not be penalized, and that is specifically the type of inequitable doctrine that would apply under Rule 6.
Let me just review those facts, the chronology in the docket. Attorney Raymond appeared on behalf of your current clients on July 13, 2009.
That's correct.
And it was she who made all of the filings and engaged in argument on the summary judgment motion.
Yes.
And she continued through the rendition of the order on summary judgment, and then in various motions seeking to address that order before she, I think almost simultaneously, just looking at the docket, filed a notice of appeal to the appeals court from the judgment language. Is that not right?
She did file a notice of appeal. My understanding was that particular appeal was given notice that it was too premature. She had filed simultaneously, though, and her motion to withdraw.
Let me just pause for a second, so I'm with you on this. February 13, 2013, notice of appeal by JOYCE Tomaselli, Grace Marie Tomaselli, to the appeals court file. The note of the office of the recorder is the record was not assembled, as there was no judgment.
Yes.
But then, after a number of proceedings here, judgment does enter. But in between the time of the order, which is in the early part of 2013, there were various motions for reconsideration, to amend findings, to make additional findings, to amend the judgment. Those were submitted in sequence here. There are quite a few of them. There's a motion filed January 25th, a motion filed January 31st, And those were all filed while, there's another motion for reconsideration that was filed in August of 2013. That was in response to the order of the court that entered August 2nd, 2013. At all of these points in time, Ms. Raymond was representing your clients. Is that correct? She does not file a withdrawal. I'm just looking for the exact date here on the docket until after there was a judgment, I believe. There was a motion for judgment. So I'm just responding to your observation that your clients were pro se during the critical points of the case.
Well, the critical point, yes, after the judgment issued, which was in 2013. So during that 2 years, the most critical memorandum order hadn't even come about yet.
So from 2009, during the time there was a filing for summary judgment and cross motions for summary judgment, hearing on that, and order issued on that, and various motions for reconsideration. Then following the finding and the entry of judgment, and through, in fact, the filing of a notice of appeal to the appeals court that was ultimately filed March 23rd, 2015, Ms. Raymond is still counsel.
She's still counsel, technically, but again, the fact that she's during counsel during that time period, you haven't issued your memorandum from the 2013. So the most critical...
I don't understand what you just said. Explain.
The memorandum, the summary judgment
Yes.
order
Yes.
was issued in
January
2013.
Right, and Ms. Raymond stays on as counsel until March of 2015. So
2015.
I think we're
Okay,
spending a lot
yes.
of your time, we're well beyond
Yes.
your 15 minutes on this, but
But
I just wanted to better understand your observation that your clients were self-represented during the
Well-
critical parts of these proceedings. They do not appear to be.
well, I think that the record is well supported that even though there technically was counsel, it was not adequate representation of counsel.
Well, that's a different argument,
That-
but
yes,
I'll leave it
yes.
there because you do need to move on. Let me
Well-
ask you to move on to the
But-
next point.
But I
We're
need to
running
address
out
the point though
time here.
about the undisputed statements, because as far as I'm reading the docket, I see the plaintiff's town of statement of undisputed facts, the plaintiff's town of response, the plaintiff's town of motion to strike, the plaintiff town of Salisbury's response to defendants, plaintiff town of Salisbury's appendix, objection. That's true. The defendants objected to the plaintiff's motion to strike.
Was it ever stricken? Was there ever an order striking?
No, there was not no. But here's the point, that there is no filing here of defendant's statement of undisputed facts. And so basically, the fact is they made a filing that was directly contrasting what opposing counsel stated, yet, which is of enormous magnitude, because those filings that they made as to their undisputed facts shows exactly why there shouldn't have been a summary judgment to begin with. And so, as shown, I specifically filed with the court saying, in direct reference to this January 2013 summary judgment, that their findings of fact were not recorded on the docket, and their response back was denied. I specifically requested an explanation as to what happened, I guess, you know, some clarification, and it just shows that this court did not have all the factual information before you to make that decision. And the fact that I had actually even brought a motion to have the record clarified and cleared for the appeal, so that they, you know, that an adequate and correct record can be shown, and the fact that the reporter issues an order and in essence saying no, you're not going to have an accurate record.
So it's your position, Ms. Belanger, that the record on appeal before the appeals court does not contain what was submitted by Ms. Raymond as a statement of material undisputed fact?
Yes, that's correct.
It's not in the record before the appeals court?
That's correct. That's correct. It's not on the docket sheet. And I suggest by...
You think it's part of the appendix material that's been on the docket sheet all along? You don't think it's part of what has been the subject of the motions, the unsuccessful motions to strike that filing?
I suggest by the actual January 2013 order, I suggest that footnote specifically states and expresses that the only thing that was reviewed was the plaintiffs. And the fact...
Where do you see that in the court's order?
Okay. Footnote 2. C. Landlord Rule 4. When moving party's statement of material facts has not been counted by opposing party.
Right. So let me
But you're saying it wasn't
Let me ask you, Ms. Belanger, just to bring your eyes up to the paragraph right before that. See at the end of it, it says, the Tomasellis filed a motion for summary judgment, and the town filed a cross motion for summary judgment. Both motions were accompanied by statements of undisputed facts. See Land Court Rule 4 and affidavits. Did you see that? I'm somewhat puzzled by your contention that the statements of fact of both parties were not before the court on summary judgment.
That on the docket sheet, it specifically shows that the only filing that had been docketed are the towns.
I think I have your point on it. I don't accept your contention. I think it's incorrect. I believe, quite convinced in my own mind, that the statements of material facts submitted on behalf of both sides, the motions for summary judgment, were before the court, were considered by the court. You may focus, please don't argue with the court. I'm just explaining to you, and then we'll move on. I'm not going to be able to resolve this for you right here, but there's ample evidence, both in the order that issued as well as on the docket, that the statements that were submitted on behalf of your clients by their then counsel as statements of undisputed fact were very much submitted to the court and considered by it on summary judgment, forming part of the appendix that was docketed, and certainly the support for that also comes from the fact that there were motions to strike that were considered and not allowed by the court.
Then how can you explain that the facts that are in their undisputed state of, under their facts, specifically contradict the opposing counsels? Because that's the whole, I mean, you're saying then that I have presented for evidence the filing that they made. In that filing, those facts are irrefutably contradictory to that of opposing counsel.
Well, we will get to that if and when we, meaning the court, in some, whether it's the reporter or me, addresses your Rule 60 motion, but the question is not whether those facts were submitted, the question is whether they were material facts to a decision by the court. And that's where I really need you to turn. We've gone on.
Well, I'd like to know though, based on the docket sheet that's presented, are you disputing for the record that the filings are docketed on this record?
Ms. Belanger, let's move on.
Okay, well, I'll take that as you're disputing it or you're not disputing
Ms.
it.
Belanger, let's move on to the next question, because I think it flows from where we are now. And that question is, can you establish for the court whether there is in fact a need for an evidentiary hearing?
Yes, well, here, the whole thing goes to, from day one, 20 years ago, the town has misrepresented to every single court that the town vote pertained to March of 1992. I have shown through the exhibits that is irrefutably false. And that was not something that my clients were able to show the court well until after 2015 into 2016. The documents show that opposing counsel, the letters show that my clients had been asking for their right to public records pertaining to a vote that pertains to a sewer construction vote all the way back to 1982.
Ms. Belanger, let me ask you then, what is the legal import of that? If I were to accept that as being so, how would that require any adjustment of the order that entered on summary judgment?
Well, I would hope the mere fact that a fraud has been perpetrated on the court would not be allowed to benefit in any way.
But you're here on a motion to alter the judgment under Rule 60B to undo the judgment that entered on the summary judgment order. So the question you have to answer for me is, what evidence would you put in if you were to have an evidentiary hearing that would lead to an opposite outcome on the motion for summary judgment?
It shows that my client purchased the property at issue in 1991. By having the vote actually being 1982, my clients cannot be responsible for that betterment charge. That goes to the original owners at the time of 1982.
And what's the legal authority for that proposition?
Budanowski is very well on that proposition.
I'm sorry, I didn't hear what you said.
Budanowski stands very well that my clients were bona fide purchasers and that pertaining to the assessment charge itself, that, because we're talking about supposedly a combination of monies, and that being part of the equation supposedly, that taints the whole kit and caboodle.
Well, let me ask you to be a little more focused in your argument than that. What is the reason that the court granted summary judgment to the municipality and denied it to your clients?
What's the reason?
Yes.
Because it's based on inaccurate factual information saying that the vote was, that there was a vote for the betterment in 1992, therefore my client had notice of this betterment.
And do you adhere to the position that actual notice is required before the betterment can become a lien against the property that would be ultimately enforced?
Yes, that's as a matter of law, Your Honor. In fact, counsel in February of 2009 outright stated that they never recorded any betterment.
Let me ask you to assume that the betterment assessment was irregular and was not an effective assessment. I'm certainly not saying that to be the case. We're just asking you for the purpose of the next questions to assume that. Do you think if that fact were established at summary judgment time, it would have resulted in a different outcome in summary judgment?
Oh, you know what? This should have resulted in no outcome to begin with, because as this court stated in its judgment, it relied on the complaint of 2006. Now, that 2006 complaint is defective, admittedly so by counsel in 2008 in the letter addressed to the reporter. This even goes further back than the summary judgment. It goes back to the mere filing of the 2006 complaint, where it goes to show you about subterfuge. Let's say this: why is the opposing counsel even objecting to the judge who heard the summary judgment motion in the first place? What legitimate purpose would they not want you to...
We're moved on to a different question. I'm asking you to come back to that question.
So,
the question I'm asking you is, were there amounts that were due and owing by your clients above and beyond those related to the betterment assessment?
we still don't know today what those amounts are. The record shows my clients were never given what this court had said was due them. They have never been broken down into what was real estate tax versus the sewer user fees versus...
But you understand that the foreclosure proceeded on a tax title account that was comprised of different elements, including taxes.
But if the complaint is defective from the begin with, you can't even get that.
That's a different point. That's not a point that has anything to do with an evidentiary hearing.
Yes, Your Honor, it does.
How so?
Because it goes to showing, because when you're on direct appeal, the focus is just exactly what happened on the record. And specifically, this evidentiary hearing is to bring in as to the other elements, what went on behind the scenes. For instance, the 2 years as to when the defective complaint was filed in the first place, why there wasn't even any notice for 2 years given to the to my clients.
Do your clients contend that they paid all the real estate taxes that were due when they were due as assessed?
Your Honor, I suggested, number one,
What's the answer to that question? Yes or no?
I can't, the answer to the question is that that's an impossible question to answer, because my clients did make payments. The opposing counsel has outright stated they made no payments. I have proof to show that they did make payments. They were actually making the redemption. I have actual proof to show that they were prevented from it. All the way along,
I'm sorry, I didn't, slow down, I'm trying to follow you. Please, you saying they did or did not make payments with respect to all the real estate taxes assessed in the relevant years?
They have made the real estate taxes to all the years.
All the taxes that were assessed during the relevant years they paid?
Yes.
Including
They gave them the check. Whether they chose to cash the check, I can't force their arm to sign it. But I'll tell you what, anything that had to do with real estate taxes, okay? I mean, here's the thing. If you look through all the years of this record, there is hide the key under the show game. Yes, the town says, well, we corrected the abatement here. No, I'm sorry, the record show here, you're looking at the tax history, but so they haven't been on a level playing field to begin with. They have made the payments pertaining to the real estate taxes. They were trying to work out, to find out what was owed as far as the sewer usage. The records show, and that is exactly what the evidentiary hearing needs to show is that opposing counsel and the town consistently hindered and actively precluded my clients from actually redeeming that property.
Did your clients, at the time the court made findings on the amount due to redeem, put an affidavit showing payment?
You know, Your Honor, I don't have the answer to that, but I suggest that why is the focus on that when they're being charged money that they're fraudulently being charged? I mean, I'm not understanding how we can go as to, okay, this is a term of, okay, what are the numbers? This isn't about what the numbers are. This is about whether we get a hearing to be able to show that opposing counsel overtly, actively concealed information. I've proven that there are letters to show that the town manager explicitly wrote to my clients stating, we do not have records pertaining to the 1982 Article 28 vote. Well, interestingly enough, because my clients are so persistent and not willing to give up on their rights because they know the truth, they were able to get the Secretary of State involved. Lo and behold, imagine that, years later, despite the town manager saying, we don't have those records, imagine, wow, they got a letter saying, here's the 1982 vote. Really interesting how when the Secretary of State gets involved, they get something. But adding insult to injury,
help me understand how the date of the vote, or in fact, anything casting doubt on the validity of the betterment assessment, would have altered the conclusions of law reached by the court in its summary judgment.
It would alter it because they would not have been responsible for it. And had they not been charged for it in the first place.
I'm sorry, responsible for what? You said they would not be responsible.
The assessment fee.
For the betterment.
The betterment. I mean,
and do you understand that the route for challenging a betterment assessment doesn't come through the land court?
We're not talking about whether they charged the right amount. We're talking about whether they defrauded the EPA
No, we're talking about whether the foreclosure judgment that entered ought to be altered or vacated.
Which is based on an assessment fee based on defrauding the EPA.
If there was a betterment assessment that your clients had difficulty with, quarrel with?
Not a quarrel with, Your Honor. It was not, it was fabricated.
And what is their relief for that?
They have submitted documents from the EPA.
I'm not asking you that question. I'm asking what is the forum, what is the legal mechanism that they have to find?
Well, it is any court, especially the land court, that can do equity. And
it's your position that the land court, in the context of a tax foreclosure case, has the authority to abate a betterment assessment?
No, Your Honor, this is not about abatement.
What is it about?
This is about an unlawful assessment that never should have been assessed to begin with.
And did you bring that claim forward? Your clients bring that claim forward?
Yes, they
In what forums?
In all the forms that you had repeatedly mentioned about all their filings, the reconsideration.
No, I'm talking about outside of the land court.
Well, they started off, of course, with the Superior Court. However, the Superior Court, as misrepresented by opposing counsel, did not address that issue.
Do you think the Superior Court made an error of law?
Yes, they did, number one.
Did you take an appeal from the Superior Court judgment?
Yes, they did, but
and
they
what was
didn't
the
have
result
the
of that appeal?
But they didn't have the information until 2015. It's impossible.
Have you applied to the Superior Court to amend its judgment? To reconsider its judgment? To revisit its judgment?
My clients did exactly what they had taken every single course of appeal of what they should from each time. And the fact is, because of 20 years of the town's outright fraud and concealing of information, they have been deprived of being able to show this back 20 years ago.
What I'm trying to get you to help me with, Ms. Melander, is the legal question, which really is at the core of the court's summary judgment conclusion, that the land court is not the place to come to a deal with a flawed or even invalid betterment assessment that is added to a tax title account that also includes other things, including conventional real estate taxes and sewer users.
We have here, Your Honor, the direct person from the EPA who can testify here as to that fraud. And
Ms. Bellinger, you're not answering my question. I'm not getting into the merits of the claim of the validity. The question is, what is the law that tells us that the land court has any jurisdiction, any authority to
because
address that?
The land court has equitable jurisdiction. And it has equitable jurisdiction right now because we didn't get the information until recently, and so therefore, under Rule 60B.
What are the exclusive avenues for challenging a betterment assessment, such as the sewer betterment assessment? It's either a suit in the Superior Court, or it's a challenge to the county commission.
No, there is no exclusive. No, there is no exclusive. Public current.
It's not what the appeals court said.
Well, where does the appeals court say that? Because we're not talking about abatement, and I suggest that the appeals court says when equity needs to be served, any court that has equitable jurisdiction can do it. That is so counterintuitive to the administration of justice that to say that to allow a decree to exist because even though it's fraudulent, you didn't go to over here. No, the land court, the way it is there are concurrent courts who have equity jurisdiction. The land court is one of them.
All right. Anything else you want to say very briefly, because we are well beyond the time that I had allotted for this, on this question of the indication or not for an evidentiary hearing to be held in this court? Take a second and just see if there's anything that I kept you from getting to very quickly.
Well, here's the thing. The judgment and orders are based on incorrect and inaccurate facts. So the summary judgment itself is based on facts that are de facto wrong, false. Then we need to go back to the issue that this whole proceeding should never have been brought to begin with. This is complete lack of due process. For the land court to even allow a knowingly deficient complaint to go forward. In fact, it's so deficient, I've given you 2 years worth of, from the time they filed the complaint, that we have the records going, ex parte communications going back and forth between the recorder, the land court, as to the actual title examination. I mean, the fraud in this case is so complete, it would have to take me like another week worth of evidentiary hearings. So not only do we have a complaint that was filed in 2006 that was deficient de facto, which your summary judgment completely hinged on. You specifically said it was based on that complaint. That should mix it right there. They wrote in writing, admitted to the court, saying that the 2006 complaint was defective in terms of numbering, in terms of land size. And here's the thing. They They have even admitted in writing that they've altered the parcel information by plot plan. That needs to be done by a registered surveyor, and I've given the codes, and the fact that the way in which they actually express that the assessor devised the plot plan should be like so outrageous to this court that I find it hard that we're even talking about the amount of money when we should be concerned with how dare the town of Salisbury commit the fraudulent acts that they have upon this court. I can't even understand how they were even allowed to file an amendment to that complaint after 2 years, when the land court's own guidelines show that the citation should have issued within 120 days. How is it that in 2007 or 2006 there was a motion for general default filed, and it was actually, as shown on the docket sheet, was actually ruled on 7 years later and allowed? I specifically asked in that motion to correct and clarify explicit information for that, but I suggest the refusal to provide that information speaks volumes.
All right, Ms. Belanger, we're at the hour mark, so I'm going to ask you to have a seat. That concludes your argument, and I'll give the floor to Mr. Comflm.
Thank you, Your Honor. Just want to clarify the record that my only representation of the town is in this tax and foreclosure case. I did not represent the town in any of these other proceedings that are referred to by Attorney Belanger. So Superior Court abatement proceedings. I represent specifically the treasurer of the town of Salisbury.
But you're aware of what's happened in those other cases?
Yes, I am.
Okay. Let me ask you first, what is your position on the request that the recorder not be the one to take up and decide the Rule 60 motion?
Your Honor, my position is clear. 185 Section 6 gives the recorder the ability to...
All right, and if I accept that view, that there's not a lack of statutory authority on the prudential grounds, whether the judge who heard the summary judgment or the recorder who then proceeded from there and eventually, after there was some delay owing to bankruptcies and otherwise that appear in the docket, eventually directed the issuance of the judgment. Is there some reason that you would contest one or the other hearing and deciding the Rule 60 motion?
No, Your Honor. My opposition was to point out that the recorder would be perfectly capable of listening to an evidentiary hearing, presiding over an evidentiary hearing, as you would also. But I wanted to be clear and voice my objection to the fact that only the presiding judge could be the judge to oversee the 60B evidentiary hearing.
Okay. Let me also turn you to the need for an evidentiary hearing. What's your position on that?
Your Honor, my position is that it's absolutely not necessary that or the order that you set forth in January 2013 was based on facts, material facts that were undisputed. Those facts did not even include anything having to do with the date that the town voted to approve the sewer assessment. There seems to be some doubt about that in 1982, 1992.
That's quite a gap. Do you believe that there ought to be any evidence heard on that question?
I don't believe so, because it's not material to the proceedings. The point is that the town of Salisbury voted to charge a betterment assessment, constructed the sewers, transferred the amount of the assessment to the assessor. The assessor then committed that tax to the tax collector to collect.
What if the court were to conclude that some evidence might come in at an evidentiary hearing that would show the invalidity of the betterment assessment?
Your Honor, Based on your decision, the court doesn't have jurisdiction to do that. Again, the defendants, the Tomasellis, have the ability to contest amounts on their tax bill by going through other procedures in law, and they avail themselves to those remedies.
And is that an answer you would give if there were no valid liens for taxes, dues, charges, betterment assessment in the entirety? Or is that an answer you give only if the validity of the betterment is the only issue in doubt?
I'm not quite sure of that question, Your Honor.
Well, in other words, you've read the Norwood case on which the summary judgment order depends in the cases that follow that case. Does it make a difference whether there is no valid tax due as opposed to some but not all of the tax validity being in question?
I think it does. It certainly does. A substantial amount of real estate taxes weren't paid.
And do you think that is true even where a betterment assessment is involved?
Yes, Your Honor. That becomes, once it gets added to the tax bill, it can be collected in the same manner as a real estate tax.
So if the facts were that there was only a betterment assessment overdue, delinquent, committed to the tax title account, and then the basis for the taking and the foreclosure action, you still think that the principles in the Norwood case would allow this court, in lieu of an action in the Superior Court to recover, would allow the party to withhold the amounts due with respect to that dubious betterment assessment and have the court determine the validity or not of that assessment?
Without any other taxes or sewer use fees or anything?
Nothing else?
Nothing else due. Well, reading Norwood, then this court would probably have the ability to do that.
Even though it's a sewer betterment assessment and not a tax?
I think my opinion is that it's treated the same way once it is committed to the tax collector to collect. So I think
the Norwood principle would obtain if there was a wholly invalid in toto sewer betterment assessment and nothing else.
I think you might have that if a charitable organization who was exempt from taxation was assessed a sewer betterment.
I see.
They would contest that. They would be able to contest that in this court.
And is there, for that reason, any value in holding any evidentiary hearing on that question?
I don't believe so, Your Honor. What I believe is the questions of what's in your opinion, what you stated, that the court doesn't have jurisdiction to rule on this matter because of the reasoning in that decision is something, is based on law, and that's the appeals court. It's up to the appeals court to make that decision. And if the appeals court would decide differently, the case may be remanded to this court. They may have a decision that would come out differently. But clearly, this was based on the law, based on material facts that were undisputed. Reading the facts, there's no issue with those facts.
What is your understanding of the status at the time the summary judgment motions were heard and decided of the statement of undisputed material facts submitted by the defendants?
What is my understanding?
Were they before the court?
Absolutely, Your Honor. They were before us. We reviewed them, the submissions, we went over them. Of course they
Moved to strike some?
Yes, Your Honor, clearly. They were before the court, and all of that information will be before the appeals court.
And you have no difficulty that, I don't know where you are, I assume there's no brief, is it no brief or appendix filed, right?
No, Your Honor.
But I assume there's no objection to including the submissions of undisputed, statements of undisputed material fact from both sides?
Not at all.
Part of that appellate record?
Absolutely not. Whatever the record is here is completely appropriate to go to the appeals court. Whatever documents, filings, memorandums, whatever that may be, the town has no objection to that.
If there were to be an evidentiary hearing ordered by the court as requested, what evidence would the municipality put in?
We would put in, I really haven't thought about that too much. I assume we would put in evidence to show that what the town did was appropriate, based on the facts that we submitted prior to the summary judgment. I don't know what this fraud is, what was perpetrated, what I've done. There's nothing in here that indicates to me anything that Attorney Belanger has submitted that would change the outcome of this based on that January 2013 decision. The taxes weren't paid. There were some taxes that were paid, not a substantial amount. They were applied according to law. We submitted many accountings, and we submitted an accounting after the summary judgment based on your order. That was reviewed by the court. It was submitted to the defendants. They had time to review it. We went over those figures prior to the summary judgment. We had the tax collector go over those figures, tax collector treasurer, to make sure that they were completely accurate. She made some changes. She made some minor changes, but she went over those figures in great detail so that we could provide the court and the defendants with an accurate accounting of what was due. And of course there's a breakdown of the taxes, the betterment, the sewer use. That's on the tax bill to start out with, and we gave that accounting to the court. So, the defendants never made an offer to redeem the tax taking. They've never done that. So I'm at a loss for whatever these issues are that had to do with this proceeding.
What is the status of the appeal, as you understand it?
It's-
I'll come back to you.
The status of the appeal is that actually nothing has happened. The defendants have not filed a brief, and the appeals court has given a number of continuances. This is over, I think it's more than a 2-year period of time. First, to allow them to obtain counsel, because they were pro se. They were given over a year to obtain counsel, and they enlisted Attorney Belanger for that purpose.
What is the status of the properties?
I believe the properties are vacant. I haven't viewed the properties. I believe there's a fence. They're fenced in. I believe the defendants are insuring the properties, but the town...
And that's subject to a stipulation that was arrived at in this court?
Yes, Your Honor, that the town wouldn't take any action.
In lieu of any injunctive relief from this court?
Correct, Your Honor. But I assume they're in a deteriorating condition, and meanwhile...
Do you know from the title the status of mortgages on the property?
I do not, off the top of my head, Your Honor, know whether they're... Obviously, the final judgment wiped out any of those liens and mortgages and so forth. But I do not know if there's any outstanding mortgages.
Or other liens, you're aware. Okay. Anything else I've kept you from saying?
No, Your Honor, it's just, I'll stand on my filings regarding presiding over the 60B hearing and my opposition to an evidentiary hearing. And thank you.
All right, thank you. Ms. Belanger, very briefly, just in, because we're way over time here, but your answer on the status of the appeal and the status of the properties?
The status of the appeal is that it's pending what goes on with the Rule 60B. The mortgage, they know very well that because of the Superior Court decision that the Tomasellis paid that mortgage off. As far as the reason why.
So, sure, just to clarify, there was no mortgage prior to the judgment of foreclosure or after?
Correct.
Okay.
So, and then, also, here's a very important thing. Opposing counsel just stood up here and said that that March 1992 vote that they claim and the 1982 one, that the real one has no significance, yet in paragraph number 7 of the order granting motion for a summary judgment, the Salisbury Town Sewer Commissioners and Selectmen voted for a $7.8 million betterment on March 16, 1992. De facto, this court did in fact say that this was a material fact because it had its own separate statement, period, the end. The 1982 does matter, and I suggest it matters so much so that the Office of the EPA is here taking the time out to be able to testify to that effect. So the fact that the EPA is actually willing to even be here to testify to that speaks volumes. And the fact that my opposing counsel wants to say they have no idea what the fraud is, it lays it out very well. You have opposing counsel in the town of Salisbury has been outright concealing information in writing about that very 1982 act, and the EPA here is willing to testify to that. And
Okay. Ms. Belanger, we're at the end. Thank you very much.
one more
I'll take the
just
matter
one more
under
point
advisement.
about
The hearing is concluded.
Thank you, Your Honor.
What's adjourned? All rise.